chance of winning this time. Here's what the Supreme Court said. And after I tell you each statement that the Supreme Court said, obviously not the 111 pages, but some of the key statements, then after each one, I would like you to say, "Thank you, Supreme Court," when I point to you. So first, the Supreme Court of California said that the constitutional right to marry is one of the basic, inalienable civil rights guaranteed to an individual by the California Constitution.
Thank you, Supreme Court!
That the right to marry must be understood to encompass the core set of basic substantive legal rights and attributes traditionally associated with marriage that are so integral to an individual's liberty and personal autonomy that they may not be eliminated or abrogated by the legislature, and get this, or by the electorate through the statutory initiative process.
Thank you, Supreme Court!
That these core substantive rights include, most fundamentally, the opportunity of an individual to establish with the person with whom the individual has chosen to share his or her life an officially recognized and protected family possessing mutual rights and responsibilities.
Thank you, Supreme Court!
That the substantive right to establish an officially recognized family constitutes a vitally important attribute of the fundamental interest in liberty and personal autonomy that the California Constitution secures to all persons for the benefit of both the individual and society.
Thank you, Supreme Court!
That statutory definitions which restrict marriage to opposite-sex couples treat persons differently on the basis of sexual orientation.
Thank you, Supreme Court!
That sexual orientation is a suspect classification.
Thank you, Supreme Court!
That the distinction between the designation of the family relationship available to opposite-sex couples and the designation available to same-sex couples impinges upon the fundamental interest of same-sex couples in having their official family relationship accorded dignity and respect equal to that conferred upon the family relationship of opposite-sex couples.
Thank you, Supreme Court!
That the state interest in limiting the designation of marriage exclusively to opposite-sex couples cannot properly be considered a compelling state interest for equal protection purposes.
Thank you, Supreme Court!
And finally, that definitions of marriage which draw a distinction between opposite-sex couples and same-sex couples and exclude the latter from access to the designation of marriage are unconstitutional.
Thank you, Supreme Court!
Give them a round. Now, obviously, that wasn't enough for the people on Yes on 8. Not enough at all. Because what they decided was, well, since the Supreme Court has said that it is unconstitutional to discriminate on the basis of sexual orientation, they thought, well, we'll just amend the Constitution. And so here's what they did, and let me give you what they did, and after each statement, I would like you to say, "We shall overcome," when I point to you. And they put the same words as Prop 22 on the ballot as Prop 8, only this time they called it a constitutional amendment. And in adopting it, the electorate first made the right to marry subject to popular whim instead of the inalienable civil right it is held to be.
We shall overcome!
And also they abrogated the right to marry by the statutory initiative process, despite the court's holding that it's impermissible to abrogate that right by that process.
We shall overcome!
They attempted to treat persons differently on the basis of sexual orientation.
We shall overcome!
They ignored the court's holding that sexual orientation is a suspect classification.
We shall overcome.
They ignored the holding that there's no compelling state interest in distinguishing between same-sex couples and opposite-sex couples for purposes of eligibility to marry.
We shall overcome.
In doing so, we argue to the court that the electors have ignored the Supreme Court's role in interpreting equal protection and other rights under the California Constitution and attempted to rewrite the court's decision on constitutional controversies that were previously settled.
We shall overcome.
Now, this week, finally, we are so happy to say, the Supreme Court of California sent me this. They've accepted our case challenging